Good morning, everyone. So today we are going to discuss about the preamble of the Constitution of India. So what is a preamble? Preamble is basically an introductory statement of a document. We see that in most of the laws there is a preamble in the very beginning. It and the preamble gives the general idea about what is going to be there in that law, what will be the articles, the sections of those laws would be discussing about, right? But the preamble of the Constitution is important. Why it is important? Because the itself is important. As we see that the Constitution is the grand norm, it is the main document of the country. It is the law from where all the other laws derive its legitimacy, its existence. And that is why the preamble of the Constitution is the most important for us to read, for us to understand. So let us first understand what the legal luminaries, what the Supreme Court, what the judges have said about the preamble. A very famous advocate of all time, Mr. N.A. Nani Palkiwala, said that the preamble is the identity card of the Constitution. So it gives you the identity. The preamble gives the identity card. It gives the identity to the Constitution. Sir Ernest Barker said the preamble is the keynote to the Constitution. Chief Justice Subba Rao said the preamble to act set out main objective which the legislation intend to achieve. So preamble gives you a general idea about what the legislation, that particular law is trying to achieve, what will be its objectives, right? In the Supreme Court, in the famous case of Rebury, said the preamble is key to open the mind of the makers, the makers of the Constitution of India. So if you want to understand that what were there in the mind of the founding fathers of our country, the people who drafted our Constitution, what they were thinking, what they wanted out of our country, what they desired that our country should be look like, then we need to study the preamble. And this is my favorite. H.M. Sirvai, the famous author, says that the preamble is a whole constitution in itself. And the rest of the articles that we see in the constitution is just the extension of it. How nicely put. So, in summary, basically, we can say the preamble is a summary. It's an essence and it is the reflection of the constitution. Now let us understand from where we have adopted the preamble. The preamble has been adopted from the United States of America. Not only India, but a lot of other countries have adopted their preamble from the United States of America. In fact, the USA was the very first country to ever include a preamble in its constitution. When we see the starting line of the US Constitution, it is similar to what we have. The starting line of the US Constitution is what? We the people of the America. And the starting line of the preamble of the Indian Constitution is we the people of India. So we have adopted that line also, that statement also. Now, let us see the history and the source of the preamble. The preamble, there was an objective resolution. It was drafted by our first Prime Minister, Pandit Jawaharlal Nehru. It was drafted by him and moved in the Constituent Assembly by him, right? And it provided a kind of a blueprint, which later became, after the discussion, which later became the preamble of the Constitution. So we can say that the objective resolution was a kind of a blueprint on which, on the after the Constituent Assembly debates, a little amendments were happened, and later it took the form, it took the shape of the preamble. Right? Now, let us understand the importance of the preamble. Why preamble is important? Preamble is important because it helps us to interpret the word of the Constitution. How? That whenever we read the articles of our Constitution, there might come a word with which we would be confused with regard to its meaning. We might, one person might interpret in one manner, the other person might interpret in altogether different manner. That could create confusion, right? And that is why, in order to understand the real meaning of that particular word, we need to see what our constitution framers were thinking when they put that word in the constitution. And then how do we do that? We go back to the preamble and read that. Then we realize, okay, this was the essence, this was the basic idea. This is what they were thinking when they wanted to put that particular word, particular law, particular statement in our constitution. Right? That is why it is said that whenever you are in doubt, look at the preamble. It gives you the underlying spirit of each word. It gives you the underlying spirit of the provisions that are there. Right? That in what manner, how we should interpret it. So it does not create any confusion, and there should be a generality with regard to how we interpret and understand that particular word or provision. And preamble acts as a north star. Why? Because whenever someone is lost in desert, what they do, they look at the north star, which provides them the direction where they should be going, right? So it helps in all those manners. That is how the preamble is important. Now, what are these objectives? These objectives are justice, liberty, equality, and fraternity. So now let us understand these important words. So let us just understand them in brief. What is justice? Well, it is a very important principle, but it is very difficult to define, right? Justice is basically a highest pinnacle of achievement of a responsible state. That it is just, that it is fair, it provides justice to its citizens, right? So that is what justice is. Justice are of three types. It can be social justice, it can be the economical justice, it can be the political justice, and various articles of the Constitution deals with these kinds of justice, right? The next is liberty. Liberty is very, very important. If you are not free, how will you develop? How will you exercise your will, right? So liberty is what? Liberty is the absence of restraint, right? That everyone will be given the free will to develop themselves in the areas they want to, right? But it is important to understand this also, that the liberty can never be absolute. It has to be restricted, right? Otherwise, one might say, okay, it is my will to steal. I'll steal from the other person, from my neighbor. And the person will come up and say, okay, I want to, murder that person because I don't like his face, right? So you cannot do that, right? And what will define those restrictions? What will define the area under which you are free to exercise your will and not beyond it? The law. And the law does. Article 19(2) provides for the various reasonable restrictions that are there, right, for your liberty. It is a famous statement we have read in various laws that your freedom ends where my freedom begins, right? So you cannot do anything and everything that you want to do, right? It has to be reasonable. Okay. The next is uh, equality, right? The equality is of three types. The first is civic equality, second is economical equality, third is political equality. Articles like Article 14, 15, 16, 17, 18 deal with the civic equality. Article 14 talks about equality before law and the equal protection of laws, right? Then Article 15 talks about there shall be no restrictions on the ground of religion, race, caste, sex, place of birth, right? Article 16 it provides equal opportunity to occupy public employment. Article 17 is the abolition of the untouchability. Article 18 is the abolition of the title, right? Then economic equality is there in the Article 39 of the Indian Constitution. It provides for that the material resources shall be so distributed as to serve the common good, and then there shall be no concentration of wealth, okay, in the hands of few people. And then it also talks about equal pay or for equal work for both men and women, right? So that is economic equality. For political equality, we have Article 325 and 326, which gives you the voting rights, which says that anybody above the age of 18 has the right to be on the electoral rolls, right, to cast vote. So all these things we see that are there, that are the articles which provide for the equality. The last one is the fraternity. Fraternity is very important. Fraternity is what? Fraternity is a sense of brotherhood. That okay, that no matter to which community we belong, no matter to what religion we belong, no matter to what region we belong, we all are aliens. So that is fraternity. Fundamental duties are specifically inserted to enhance this idea of fraternity, idea of brotherhood. In the fundamental duties, we see that there are provisions to respect the national flag, to cherish the noble principles of the independence struggle, to defend the country whenever called upon, right? And to build a composite culture, to protect the sovereignty and integrity and unity of our nation, right? So what all are these? This all these provisions are there to inculcate a kind of a feeling of oneness, right? That though we are different, but we are still one. We are still the same. Then we also provide for single citizenship, right? Unlike Canada, unlike USA, which provides for dual citizenship. So that why do we do that? So we do not say that okay, we belong to Uttar Pradesh or we belong to Rajasthan. There should not be any regional differences. We will always and in one voice should say that we belong to India. That is what fraternity is. Okay. Now let us come to the next slide, which talks about that whether the preamble is a part of constitution or not. Well, in the early years, in the 1950s and 1960s, there was a discussion between whether the preamble is a part of the constitution or not. In the famous Beruberi case, the court said no. The preamble is very important, but it is not the part of the constitution. But later on, it was overruled by the famous case of Keshwananda Bharati, where the judges said that the preamble is not only the part, but it is an integral part of the constitution. So now, as the situation stands, the preamble is a part of constitution. Now, the next question is whether it is amendable. Well, as I have already told you, the words like socially secular have been inserted by this 42nd Amendment 1976. So yes, it is amendable. It has been amended only once so far. But after the Keshwananda Bharati, it was decided that okay, the preamble is amended, but the principle, the values which constitute the basic structure of the constitution cannot be amended. Because if you amend that, then that will be altogether a different constitution. That will lose the essence of the constitution, and that should not happen. So the words democracy, republic, secularism constitute the basic structure. Those words cannot be amended. The preamble can be amended as a whole. Some words can be inserted, but the basic structure principles, the basic structure doctrine cannot be touched. Okay. Now, is it justiciable? What does justiciable mean? Justiciable basically means that whether it can be enforced in courts, whether you can seek any remedy by enforcing the preamble, saying what, okay, there are certain words which are there, and now it is, and now this particular action by the state is against the words which are there in the preamble, and that is why I want relief. So, can you do that? Well, no. It cannot be enforced in the courts. It is not enforceable. It is, and also it is not a source of power to the legislation, right? What then? What it is? It is basically a guiding light. And whenever you are confused, whenever the judges are confused with regard to the particular provision, particular article, particular word, then they go back to the preamble and read those words in its, in its, like in a complete manner, and they get to grab the meaning of it. It also helps in the interpretation of the constitution, like I said, right? So that is why it is not just